Hello, my name is Danya Palanker, and I'm Senior Counsel at the National Women's Law Center. This webinar is entitled, What are Large Employer Responsibilities? I will provide an overview of what the health insurance responsibilities are required of large employers under the Affordable Care Act. This webinar provides an overview of the rules. I should note that the rules we are discussing are actually only proposed at this point, and they have not yet been finalized. So there may be changes. Final rules are expected within the next few months. In addition, many employers have complicated situations, and we recommend you confirm your status with your own legal counsel or benefit consultants. So what do you need to do? Well, first, the employer responsibilities don't start till 2015. There's no responsibility for 2014. That means even if you're a large employer, you do not have to offer coverage to your employees in 2014. However, starting in January 1st, 2015, if you are a large employer, you need to provide coverage to all your full-time employees and their dependents. The coverage needs to be adequate and affordable, or you may pay a penalty. And now I'm going to walk through what these terms and requirements actually mean. So first, who must be offered coverage? I noted it was to all full-time employees and their dependents. Full-time employees are defined by the law as employees regularly working 30 hours or more per week. Now, there were special rules proposed to address variable hour employees. Those are employees that work different hours each week or that you hire without knowing how many hours they will work. This could be an important rule for child care centers because that may have a lot of employees who work on call or otherwise have flexible hours. In addition, seasonal workers do not have to be offered even if they work full-time during the time that they're seasonal. So if you only have employees working one season, for example, the summer, they may not be considered full-time employees. In addition, you have to offer coverage to employees' dependents. Now, spouses are not considered dependents under the proposed rule. This is because spouses are not dependents under the tax code. The term dependent has a different term in tax law than it generally has in benefits. When you fill out your taxes, if you have a spouse, they basically are in a different category on the tax form. The proposed rule would therefore only require an offer of coverage to employees and their children who are under 26 years. And what must be offered? Employers can offer any health insurance, but if the coverage is inadequate or unaffordable, they may still have to pay a penalty because an employee can waive the coverage and go to the marketplace. And when I say any health insurance, it needs to be health insurance. They cannot offer something like a health discount card. Adequate coverage under the law is defined as coverage that costs at least 60%, covers at least 60% of costs. Now, there are many different health plan designs out there, and employers can cover different services. In determining whether a plan meets the minimum value of 60%, that plan is compared to the larger market of the large employer market and what benefits are covered. There's actually calculators and tools that are available for your insurance company or consultant to help with this calculation. Now, I should remind you that there are no specific benefits that have to be offered by this provision, but there are certain coverage requirements and benefits in other aspects of the Affordable Care Act that plans must cover. For example, all new health plans have to cover preventive services without cost sharing. Now, to be affordable, the cost of the coverage to the employee, basically the employee share of the premium, must be less than 9.5% of household income. Now, this is just the premium. It doesn't include the employee's cost sharing. Now, how do you as an employer know household income? You don't, and you probably don't want to start asking all of your employees. But there will be safe harbors based on the employee's wages or salary that help employers calculate this and protect them in the case that coverage is unaffordable for one or more employees. The affordability is based on the employee share of the employee's premium for self-only coverage. Self-only is what many people more typically know as employee-only coverage, so it's not based on family coverage. Now, there are two potential penalties. The first penalty is if you are a large employer and don't offer coverage to all or some of your full-time employees. In that case, you have to pay a penalty of a $2,000 annual penalty for each full-time employee, and you subtract the first 30 employees. So that annual penalty equals $2,000 times the number of full-time employees minus 30. So for example, if you have 100 full-time employees, you subtract 30 from 100 for 70. Then you multiply $2,000 times 70 and would have an annual penalty of $140,000 if you don't offer coverage. Now, the second possible penalty is if you offer coverage, but it is inadequate or unaffordable. Now, in these instances, it's a $3,000 annual penalty, but that penalty is only on an employee that waives coverage and receives financial assistance, also known as tax credits, in the marketplace. Now, you'll never pay a higher penalty than if you don't offer coverage at all. And there's no penalty for employees that waive your coverage but enroll in Medicaid. Now, the annual penalty, therefore, equals $3,000 times the number of full-time employees receiving tax credits. So, for example, if you have 100 full-time employees and offer all of them coverage, but the coverage is unaffordable for 3 employees, what happens? Well, let's assume one of those employees remains uninsured and 2 receive tax credits through the individual marketplace. In that case, your annual penalty would be $3,000 times 2, or $6,000. The penalties are actually determined month by month. So if one of the employees resigns after 6 months, you only have to pay a penalty of $1,500 that year for that employee because it's only paying for 6 months of penalties. Thank you for listening. Please look at our other webinars available to help child care employers understand changes under the Affordable Care Act. We will be providing additional information on the employer responsibility once the final regulations are issued, so please keep your eyes out for that information.